Once again, this is the Marshall Enterprises presentation. Peace, everybody. Welcome back to another edition of Brownsville LLC. I got a bit of information for you that I know you can use. Has to do with filing documents at the county clerk. What to do when they refuse to accept your paperwork. And usually there's reasons why they don't accept it. And it has to do with if you're following the procedure or not. And oftentimes, public officials or lawyers or attorneys, paralegals, they do this work. They enter documents into the county register. They file documents for cases and what have you. So when you as a layperson comes to do the same thing, they are not so quick to help you because you are expected to know what you're doing. And again, they're not too thrilled to help you out. Every now and then you'll get that one employee that wants to do their job and they, you know, are enthusiastic about people using the system and using their abilities or using, you know, using the services that is readily available, because a lot of this stuff is not just for the attorneys or paralegals to do. A lot of this stuff you can do yourself. You just have to know the procedure. So get the procedure right and you should not have a problem. So this document that I came across a while ago, I'm sending to a friend. He asked for some information and I read it and I thought maybe I'd do a video on this one as well. This is some very, very good information. And oftentimes people call me for advice and I go through my wealth of flash drives, find information that they need and I send it to them. And I've been thinking lately, why not make a video on a lot of these files that I've been sharing behind the scenes? Because I can help a lot more people this way and I may not get as many calls that would help. You know, I try to answer every call that I get. I try to help everybody that reaches out to me. But if I can make a video that will help 10 people and that's 10 less people calling me, that'll be great. Not that I don't want to talk to you guys, but anyway, let's get into the document. When a county clerk, recorder of deeds, etc., refuses to record, by David DeReimer. Most legal remedies for misconduct or crimes committed by government officials must be formally presented and officially sanctioned by the courts. Inevitably, the cost of litigation in the courts inherent reluctance to favor private citizens who sue the government and teach us that we can't sue City Hall, even if the folks who work there are crooks. Shielded by the official and practical immunities inherent in our legal system, government officials are encouraged to believe they are above the law, beyond the reach of common people, and free to abuse their powers. No longer accountable in court, the frequency of official misconduct, oppression, and injustice is rising, but normally unpunished. Commercial liens seem to have extraordinary powers for attacking government officials who break the law. The key to the liens power is found in the fact that these liens are applied non-judicially, without the knowledge, approval, or interference of a judge, because the judges aren't involved. They can't stop you from filing your liens, and therefore they can't shield the government. Instead, to file a commercial lien, you prepare the necessary documents and simply file them along with the modest filing fee with the local county clerk, recorder of deeds, etc., or whatever county agency is responsible for filing public documents. And pausing here for a second, I also have a document for you that outlines how to access the courts for free. And it's not an official document. It's has case law that points out where we are supposed to be allowed to use these services free of charge, because the counties are making money. The counties are charging us fees for things that probably should be no charge at all. However, if they can make a buck, they're going to make a buck because of our ignorance our lack of understanding. So I'll try to find that document when we're done with this. Moving right along, but the problems are beginning to develop. Since the legal system can't stop these liens with high legal fees and biased judges, the county clerks are beginning to restrict the filing of liens. In other words, you prepare your lien, round up your $50 filing fee, and present yourself, your money, and your lien to the county clerk, and he refuses to accept the lien. The lien can't work if it's not filed. So a recalcitrant clerk can stop your lien cold. Although the clerk's refusal to file the lien document is almost certainly unlawful. I've heard reports that refusals to file are increasingly common in California, Ohio, and other states. The following is one man's recommendations for dealing with the county clerks who refuse to file your liens or other documents. This procedure is primarily based on the Uniform Commercial Code. Because several of the steps require you to wait patiently, 30 days or more, for the government's response, the total process may take 6 months or more to complete. These lengthy delays are difficult for those of us who are used to a diet of instant TV, microwave food, and fast gratification to accept, which is to say, here's another obstacle: time. Our legal system uses to prevent people from compelling government officials to obey the law. So be it. But what does it take to overcome this obstacle? Just patience, persistence, and determination. The first one, 2, or even 3 individuals who fight to compel the clerks to properly record their liens may have to struggle for most of a year. However, once the clerks begin to see their personal liability, they'll return to obeying the law and recording the liens. It may take time, but it's clearly time that must be spent by a handful of people to open the doors for the rest of the public. And I'm going to pause here for another word to the wise. Oftentimes, these individuals that work at the front desk, they are taught procedure. They are taught, like when someone is new to a job and someone that's been there for years is now training them, they are training them on the procedures that they were taught. Oftentimes, you won't see a manual or like a procedure guide explaining to you what you should do and how it should be done. So there are legal policy or legal outlines of all of this stuff that needs to be followed. But oftentimes they're not following this stuff. What they do is they do what they were taught to do. Okay, only accept this if they have ID. Don't accept this if it's not signed. Don't do this, don't do that. Some of the procedures or the rules that they follow are in line with what they are supposed to be doing. However, they add little things in, or they do extra things because their supervisors tell them. The supervisor will tell them, well, if they don't come with a notarized document, don't accept it. If they don't come with this, if they don't come with a cover sheet, they add certain things in that put obstacles in your way. But if you know the procedure, study every county, every agency has rules and guidelines. Read them, look for them, read them, and if they are challenging you, get them to show you in writing, where they drawing their conclusion from. But this letter goes into it, so let's continue. In general, it looks as if the liens can be used to compel the judge and public officials to obey the law, and the Uniform Commercial Code can be used to compel the clerks to obey the law. Point: where there's a will, there's a legal remedy. Advice: learn to work with others. Your witnesses are your friends, advisors, and legal safety net. Unless you have absolutely no choice, don't try to lean on government officials all by yourself. Bring at least 2 witnesses along to every face-to-face meeting with the clerk, recorder of deeds, sheriffs, etc. After the meeting, have your witnesses prepare sworn affidavits of whatever they saw and heard the clerk, official, sheriff say, do, etc. If the clerk refuses to file your lien and you have no witnesses, it's really just your word against his or hers. And if the clerk refuses to provide a written explanation for his or her refusal, it's still your word against his. However, if you bring witnesses, the officials will be more intimidated and less likely to refuse your lawful demands in the first place. It may take a little persuasion, But if the clerk begins to suspect they are being trapped into a potentially litigious situation, they'll be more likely to cooperate and file your lien or call their boss, and thereby generate more witnesses and more public controversy. If the clerks, officials, etc. still refuses to do their sworn duty, your witnesses and their affidavits will provide a solid foundation for pursuing stronger legal remedies. Finally, as is always the case with instructions, forms, etc., bear in mind that the following recommendations were not provided by a licensed lawyer or sanctified by some judge. What follows is only a study guide intended to outline one man's notion on how to compel government officials to do their sworn or lawful duty. Before you apply any or all of these recommendations, you must do the necessary research to confirm the strategy is valid and can be lawfully applied to your local county clerk, recorder of deeds, sheriff, etc. This is from the editor. When the county clerk, recorder of deeds, etc. refuses to record, this is what you do. 1, get a written explanation, reason, or excuse from the clerk who refuses to record your document. This is the first link in your chain of evidence. Number 2, as per your state uniform commercial code, section 3-505-501, that may not be the code in your jurisdiction, but look it up. Send a notice in demand for exhibition or presentment without dishonor by certified mail to the office, county clerk, recorder of deeds, etc., that refuse to accept your lien. In that notice in demand that they produce for your inspection, A, the statute or law passed by the legislature which authorizes them to condemn the public records for their personal and private use. B, their personal bar lawyer ID number issued by the state bar or state Supreme Court which authorizes them to make legal determinations. And C, the statute of law passed by the legislature which authorizes them to edit and or censor documents prior to recording. Give them reasonable time, 30 days, to comply with your demand to prove written authority, and then put them on notice that the law of principal and agent specifies that the agent is personally liable for acts not authorized by the principal. As such, unless there are laws granting the clerk the power to refuse to record certain documents, the clerk, agent, has no corporate veil of immunity for his or her refusals and may be personally vulnerable to a lawsuit. 3, if the reasonable time has elapsed and they have failed to produce the written authority you demanded, send a notice of default by certified mail, notifying them that they have defaulted by not answering. In it, provide them with the right to cure their default by recording your original lien or other documents without further interference, or suffer the consequences. Allow 10 to 30 days for their response. 4, if they don't respond in the 10 to 30 days, send them certified mail, a notice of amount due for the damages caused by their injury to you or your property rights, by their defalcation, dereliction of duty, default, and unauthorized refusal to record in a sizable amount, $1,000. Again, give them reasonable time, 30 days to pay you. Now I'm going to reread that. Number 4, if they don't respond in the 10 to 30 days, send them certified mail, a notice of amount due for the damages caused by their injury to you or your property rights, by their defalcation, dereliction of duty, default, and unauthorized refusal to record in a sizable amount, $1,000 or so. Again, give them reasonable time, 30 days to pay you. Number 5, after the 30 days, a reasonable time has passed, plus 4 or 5 days for the mail, send them certified mail a final notice of amount due for the damages caused by their injury to you. Again, give them reasonable time, 30 days, to pay you the amount of damages you demanded. Number 6, if they don't pay your final notice demand in 30 days, plus 4 to 5 days for mail, go to the county elected peace officer, sheriff, present copies of the 2 certified mail demands for payment, sign a distress warrant or distraint warrant stating that you have not been paid, and have the sheriff go get your money or sell the clerk's car, mobile home, boat, motor trailer, or whatever to get your money for you, just like the consumer finance lenders and the IRS do. 7, at any stage of this procedure, you can send the offending clerk a letter and offer to settle, right to cure default. If they will perform their sworn duty and record without debate your document or lien. If they fail or refuse, go on to the next step in the procedure. The purpose of this procedure is to force them to do what they are paid to do, not to sell their car, boat, whatever. Even after the sheriff takes some of their property, you might still offer to give them back their car or whatever if they will record your document without further question. This is to show good faith. Number 8, if the sheriff refuses to perform his sworn duty to execute upon your distraint warrant, inform him that you personally will perform his sworn duty for him on his behalf. Inform him also that the newspapers will be informed that he has refused to perform his own sworn duty but continues to cash his paycheck, and that this constitutes fraud by him since he only performs selective enforcement of the law, which is unlawful. Inform him that the resultant publicity may have a negative impact on his chances for running for re-election, and that you may have to sue him in his personal capacity for money damages due to dereliction of duty, defalcation or defalcation, embezzlement of public funds, and damages due to his injury to you and or to your property rights. Number 9, send the sheriff certified mail a notice of demand for production or exhibition without dishonor of the law or statute that authorizes him to A, perform selective enforcement of the law, B, accept the people's pay and not execute on lawful warrants, C, personally edit and censor documents or refuse to perform his duty under his sworn oath, which is perjury. 10, if either the sheriff or the recorder of deeds says that they take their orders from some government lawyer, get that in writing. This admission and confession becomes a second link in the chain of evidence or preponderance of evidence that you will be creating. After and only after you have the above admission and confession in writing, leave their office. Alternatively, you may bring 1 or 2 witnesses with you who will later provide affidavits describing what the sheriff or recorder said. Then perform the previous certified mail step number 2 and add item. D, provide the statute of law passed by the legislation that authorizes them to relinquish their office over to another, whoever, regardless of whether they're government attorneys or not, while continuing to accept and negotiate, cash their paychecks after having turned over their offer to said other. Remember, you are exposing a humongous scam. The Lawyers Club has usurped the government from the legislature and from the people, and you are exposing this fact. Do not expect Satan to give up easy and go home. He and his minions never have before, so why expect them to now? They're all part of the New World Order, and they are the Politburo, whatever that word is, of the party. They truly believe that they are the chosen few to dictate the lives of the sheeple on behalf of the world, corporate, money mafia, banksters. More helpful information. When dealing with the registrar or recorder, don't allow them to make any legal determinations for you. If they say this doesn't look right, or this doesn't seem legal, or I don't think you can terminate the IRS lien, or any other unsolicited legal opinion, answer this way. I have not hired you to represent me. I do not give you permission to make a legal determination for me. If you do make a legal determination for me without my permission, you are practicing law without a license. Practicing law without a license is a commercial crime. You can also research your state code. Look for that section, look for the section concerning crimes against justice. You'll probably find 2 or 3 sections pertaining to destroying and stealing public records, conspiracies to defeat enforcement of laws, destroying or stealing records by officer in charge. This information, along with the penalties, of course, can be made into a notice you can use when you go to get your legal instruments recorded. Suggest that the recorder just stick to his or her job, which is to record legal instruments like your UCC3s. Stand your ground and be persistent, but not abusive. If the recorder refuses you no matter what, you should proceed at once to use any and all legal options against him. Get the criminal charges filed first. Bring copies of the complaint and arrest reports along with your affidavits to the bondholder. Make sure the bondholder knows that you intend to make him criminally liable as well if he continues to carry a bond on this person. The affidavit showing wrongdoing on the part of the recorder and how you were damaged as a result, along with the copies of showing the man has been criminally charged and arrested for his actions he took while on duty in his bonded capacity, should be very effective. Bring a tape recorder in a pocket or purse. You can't use the tape as evidence, but it will help you with details if you need to make affidavits to revoke his bond. If you ruin his career, the guy who replaces him will have learned a lot about who's in charge and will be more accommodating. Even after you get these notices terminated, you may still have trouble with an employer if a notice of leaving shows up. You can contact American Rights litigators at phone number 352-383-9100. I'm not sure if these people are still available, if their number is still valid. I'm just reading a letter or reading a notice. They can also help by writing very professional letters for you to use on any third parties such as banks and employers. Remember, you want the resultant document, the release of the lien. The same laws under crimes against injustice apply here as well. The registrar is not allowed to withhold the resultant document from you. Point out that the incorrect recording of the IRS 668 notice has caused damage to you. The IRS 668 notice should be recorded as a notice and not a lien. When they record it in the lien book, it becomes negotiable and enforceable. This is the root of the problem. Attention, California and possibly other states. Recent information coming out of California indicates the state code has been changed to allow the recorder to edit and to refuse your legal instruments. Do not despair. A friend in California reports he has dug up the legal remedy. Apparently, the Secretary of State now has the power and the burden. If the county recorder refuses you, you can have your legal instruments served on the Secretary of State. He is required to record it. This, of course, will still not get your UCC-3 into the county recorder's office where it belongs. So the following is a suggestion. Include a cover letter informing him that since your right to record legal instruments at the county of the name of the county has been compromised through legislation, you expect him to represent you at your county to certify the recording of your legal instruments there as well. Mention you want to be notified by mail of your certification of your legal instrument at said county recorder's office. Details on served are sketchy. It might just mean certified mail. Find out. Research your state's code. After you get it all done, please help someone else with theirs. Be their coach or witness. We've got to work together. Basically, what the gentleman, David, let me get his name right, David DeReimer has outlined here is an administrative process. You serve the person or the entity with your notice, your original notice. You follow up with a opportunity to cure, and then you follow up with that with the notice of default. And you have to initiate a case. If you go through this process, an administrative process that is, and you don't follow it through, you have just wasted your time and you more or less wasted anybody else's time that is involved. Because the only way that you're gonna actually see the other side is by seeing, you gotta follow through. You can't make a threat and not make good on your threat. Because once your bluff is called, then your bluff's gonna be called each and every time. But if you initiate this administrative process and you follow through, whether you're successful or you're not, it shows them that you're serious. Because you might fail on the first one, but you may not on the second and third try. All right, so again, this is an administrative process, but it's showing you what you could do in the event that the county clerk or county recorder refuses to file your paperwork. So read over this document again, play the video again, slow it down, and look up what it's telling you to do in your jurisdiction, in your county, in your location, and see how the rules apply and the procedures apply in your area. They've also quoted UCC numbers in here somewhere. Make sure that those UCC numbers that they quoted are the same numbers in your jurisdiction, because they changed. It's going to be in the same vicinity or like in the same area of the code, but the numbers may be different. So you don't want to quote Washington's quote or Washington DC's code for New York, and it's in two different locations. So you want that to be consistent. But this has been a presentation on when a county clerk, recorder of deeds, etc., refuses to record your document. This is presented by David DeReimer, and this is Bud Brownsville. Thank you for listening. I hope this helps someone, and if this helped you, please subscribe, click like, share, and tell somebody else about what you just read or just heard about. So peace, everybody. Have a great day.